I call this my coming out of the closet song. I'm not at all ashamed to say that I'm growing marijuana in my yard. Growing marijuana in my yard. I got little pots of pipe spread out all over the lot, 'cause I'm growing marijuana in my yard. Well, I got the seed from Mexico. Stick it in some dirt and let it grow. Put it in my garden with my peppers and my peas, and I get all the smoke I need for free. 'Cause I'm growing marijuana in my yard. Growing marijuana in my yard. We'll keep it where no one can see, so let's keep this between you and me. But I'm growing marijuana in my yard. 'Cause I'm growing marijuana in my yard. I can't tell I'm boss or I'll get fired. I don't grow much, just what I use. I work all day, and when I'm through, I smoke some marijuana from my yard. Now the policeman wants to talk to me. He says, how you gonna smoke up all that weed? He says, money's what you're in it for. Don't you know we're in a war? Now I'm gonna haul your ass downtown with me. I said, hey man, what is it to you? How do I infringe on what you do? Well, I beg your pardon if you're offended by my garden. I just can't grow Prozac in my yard. So I grow my own medicine in my yard. I give some to my neighbor for his heart. Share it with my grandma and keeps it from her son. 'Cause we all know that stuff's against the law. Well, now there's nothing growing in my yard. 'Cause cops to call my lane and both my cars. Now I have to buy my pot from a teenager in the parking lot who's growing marijuana in his yard. Oh, anyone can grow it in their yard. Hey, I can show you how. It ain't hard. Never mind the president, let's overgrow the government and all grow marijuana in our yard. Let's grow some marijuana.
What are your very thorough and voluminous application today? Anything in addition you'd like to mention?
Yes, sir, I would like to read this into the record.
Is it above and beyond what you've already made? We're not at sentencing. We're just dealing now with your motion to withdraw your plea.
We're not sentencing now.
No, I haven't decided yet your motion to withdraw your plea. If I let you withdraw your plea, then we don't go to sentencing.
Okay, if we go to sentencing, I would like to read this.
I think you will be permitted to be heard if we reach that stage.
Yes, Your Honor.
Anything else that you would like to say by way of supporting your motion to withdraw your plea?
Yes, sir, we would like to.
But it would only be above and beyond what has already been stated in your papers or already argued for. You understand that?
Yes, sir.
So go
We
ahead.
as sovereign human beings withdraw our plea.
I think that has been mentioned once or twice. Respect the fact that you're a sovereign human being. Anything else? Any other legal arguments?
I believe that this court lacks jurisdiction to go any further.
I understand. And I think we've addressed that before, but that's clear. Anything else?
Not at this time.
Again, Mr. Barton, we've spoken about this several times. I truly believe that it would be in your best interest to have an attorney represent you, as we stated repeatedly. At the same point, I also have found and respect the fact that you have a knowledge of the law, and these hearings and And at least during the course of the times you've been in court, you have shown respect for the process of justice and respect to the court. Whether or not you respect the individual is a question I don't even care to ask or know the answer to, but you have shown respect for the process of this court. That's appreciated. But I will give you that opportunity again should you wish to have counsel represent you at this stage.
But I also would like to move this court to dismiss on the fact that in the MAP hearing, we proved the police officers admitted that on 2 occasions they trespassed without a warrant to gain evidence to get a warrant.
You never allowed me to make my decision on that, sir, because you went to plead guilty before we completed the hearing.
Well,
I never made a decision on that MAP hearing.
and I ask you to make a decision now, Your Honor.
Not after you pled guilty, because the hearing had not been completed.
The prosecutor had committed fraud by telling us that he told us in the back room that he believed that you would not throw it out on the fruit of a poison tree. He also said that more than likely it would go to trial.
I'm not saying what the decision would be. I couldn't possibly say what the decision would be because the hearing was not complete.
Right, but I'm saying our plea and fraud was perpetrated upon us to bring about that plea.
And so you can understand, fraud is not perpetrated by a prosecutor when a prosecutor believes or tells a defendant that they believe they're going to succeed at a suppression. They're just telling me what they're believing. I don't know what happened, but assuming that he told you that his prosecutor came forward and said, I think I'm going to lose this one. Well, that was to demonstrate a lack of confidence in himself and also the case.
I believe the prosecutor committed prosecutorial misconduct when he knew at that point that the police officers were twice on the property without a warrant, looking in the windows to try to gain evidence to get a warrant, which would be the fruit of a poison tree. For him to proceed further, I believe that he should have asked for a dismissal in the interest of justice. By him not doing that, knowing the facts, he committed prosecutorial misconduct, Your Honor.
That claim is noted for the record.
Yes, Your Honor.
But if this court did not have an opportunity to decide the motion, it's moved at this point to present the plea guilty.
4 hours, we realized that we had been tricked, and we came back and withdrew our plea.
And we've argued that, we've discussed it both in papers and also during oral argument. Is there anything else above and beyond what you've already argued in your substantial papers or during oral argument?
Not that I can think of.
Mr. Debberman.
I'd like to say that this court and the prosecutor are acting under color of law because they never proved to have lawful authority to put us on trial in the first place. They never included warrants for the dates of November 5th and November 10th, 2008. And the police testified that they did not have a warrant. We were under the impression that the court was going to suppress the evidence once they realized it was obtained illegally, but instead they took us into the back room and forced us to demand the plea. And because the court did not do the right thing, they committed a warrant.
What was the right thing to do?
Was to suppress the evidence because it was obtained illegally.
The court never had the opportunity to make a decision on the suppression hearing. The suppression hearing, the testimony at the suppression hearing had not been completed. I can't make a decision on any motion until the hearings are complete, until both sides rest. I understand that's your argument. You made that argument. I'm sorry.
It was all proven on the record prior to any plea.
And what was proven?
that the police trespassed without a warrant. They admitted that in their own words to get evidence of probable cause to get a warrant. It is illegal.
And that's
It's not a valid warrant.
That's a decision that the court would have to make at the completion of suppression testimony of suppression hearing, allowing individuals to make their arguments after the testimony, after both sides have addressed it, allowing them to court in its discretion to this memorandum of law. The suppression hearing is never complete. This court will not make the decision based upon partial testimony. That's where the guys didn't take it. Another time, Mr. Barton, back to Mr. Debberman.
Both you and the prosecutor were well aware that the evidence was obtained illegally.
That is absolutely unequivocally inaccurate. I don't know what the prosecutor is aware of and what they're not aware of. I do know that this court has absolutely no awareness of any evidence being seized illegally. Suppression hearing is not complete. There are many exceptions to a warrant requirement. There are many exceptions that allow police officers to be upon property. None of that was completely litigated before me, and I was never given the opportunity to make that decision. And I'm saying at this point, unequivocally, this court has not formed any opinions, because I will not do that until I hear all the proof. That's the direction I give to the jury. It's a matter of law that I must follow myself. I must follow all of the proof before making any decision. I did not do that. So I am not in a position to make that decision. And most certainly, I have not even opined that any rights were violated, nor have I opined that any rights were properly pursued. It has not been informed. Do you understand that?
We're telling you our rights were violated.
I appreciate that.
That's what you're on?
And you may always say that you feel your rights were violated, but don't say that the courts. The courts treat you as warrants. I could. Yes.
In the interest of justice, I would ask Your Honor to allow our plea to be withdrawn, considering that in the MAP hearing, 4 officers admitted to being on the property without a warrant, which would make any evidence that they obtained to prove the poison tree.
Respectfully, sir, I disagree. I'm not going to talk about what the testimony was or was not. Simply, a police officer being on individual's property without the benefit of the warrant is not Fourth Amendment.
So they were looking in windows and sniffing the door.
Never heard the full testimony. They never had all of the testimony, so this court is not in a position to agree with it.
Let us take back our plea and let's go further with it.
That's what I have before me now. Is there anything else that you would like to do? Anything else that you would like to do? You don't have to raise your hand just because one person is done. That was Mr. Jess. And you are, and I do appreciate that. Trust me. Trust me when I tell you I've handled multiple murder cases and have not gone this long. And I'm doing everything I can to ensure that you have a fair hearing. And I have repeatedly recommended that you allow me to assign counsel. I have informed you repeatedly that I need to make a mistake. Now that doesn't mean that I formed an opinion for instance. It doesn't mean I formed an opinion as to whether or not the search was illegal or illegal. I just strongly believe that it would be in your best interest to be represented by counsel. Now, I can't force you. You have a right to represent yourself. You've been through this repeatedly. Now, Mr. Debberman, my apologies.
Dennis Doyle already admitted that he searched the interior of our house from the exterior by looking at windows and sniffing at doors. That's already a search of the property. That's not evidence of probable cause to get a warrant. He said that he didn't see anything.
What is your point?
Just the alleged odor of marijuana while trespassing on private property is not probable cause to get a warrant. And Detective Dirk Flood didn't have first-hand knowledge. He's going on hearsay, basically, from Dennis Boyle, who trespassed.
I'm not going to discuss with you or argue with findings of fact, credibility, what one witness said and what one witness didn't say, because I do not have scope of testimony. What I will say are myriad exceptions to the warrant. There are justifications for people being personal product, police officers. The smell of marijuana, in some cases, in and of itself, allows probable cause to believe a crime was committed. These are all legal issues. So a blanket statement that your rights were violated under the circumstances this court cannot agree to, for the reasons I've already stated. Yes, Mr. Barton.
Once again, we ask Your Honor to protect our rights to due process and equal protection and withdraw the plea that we have withdrawn.
I have done everything humanly possible, Mr. Barton, humanly possible, to protect your rights, including repeatedly advising you that it would be in your best interest to represent. I've done everything I can except represent you myself, which I'm not permitted to do. Under these particular circumstances, it is my obligation to ensure that everyone has a fair hearing. For anyone to attempt to indicate that you've not had a fair hearing would be disingenuous. And I truly, when you're here, and I hear you make those statements, I believe you. However, at the same time, I am obligated circumstances, unless you have established legal basis to withdraw your plea, I'm not inclined to do it. Are there any other arguments either one of you have concerning the issue of withdrawing your plea?
Well, we believe it was coerced, and it was a product of fraud on the prosecutor's part.
Is there any allegation that the court threatened you to plead guilty?
No, Your Honor, but I do believe that you have tied our hands throughout the whole trial and left every advantage for the prosecutor.
How did I do that?
Well, a lot of our motions, you picked and chose what to answer and didn't answer a lot of them. You allowed the prosecutor not to answer many of our motions, including our bill of particulars, which the prosecutor refused to answer.
How many motions did you
Maybe 15 or 20.
Mr. Barton, my last year as chief assistant, I can't recall, I handled the first death penalty case in New York State. First one. The abduction and murder of a child. Second. You filed almost as much papers as that.
I have the right to do that.
Well, I'm not so certain you do, sir. In fact, I'm certain you do not. In this state, you are required to file your motion within the discretion of the court in the fashion of an omnibus motion. You do not have a right to just file motions every other day. You do not. Having said that, you are directed to file your motion omnibus form. One motion. Virtually each and every motion that you have filed has been answered by this. Unless this court found it was repetitious. I haven't picked and choose everything. And this court and its court's attorney have spent an inordinate amount of time doing everything we can to ensure that you have a fair hearing. But when you invoke your right, it's a constitutional right to represent yourselves and not have an attorney, I
cannot represent you. Can't do that. There's simply nothing more that I can do to ensure that you have a fair hearing. And you may not like my decisions. Most people don't. Many times the prosecution doesn't like my decisions. Probably repeatedly today, they didn't like my decisions. I make decisions I believe are fair and just, and in accordance with the law. That's all I can do. Any other arguments other than what has already been written or already orally argued in reference to
Not other than we're a sovereign citizen, we withdraw our pleas.
Mr. Debberman?
I feel that you're not really being fair and impartial, and that you're allowing illegally obtained evidence to be used against us. But just
Sir, I've not made a decision on it.
Oh, I'm sorry.
No, you don't have to apologize. I've not decided one way or the other because I was not given the opportunity to decide.
Withdraw
You're
our
not
plea.
here.
We want you to have the opportunity.
You'll have the opportunity.
Yes.
The plea, it was, as far as I'm concerned, it's a void proceeding because the court lacks jurisdiction or lawful authority because the chain of jurisdiction was broken by them never having a warrant that was proven never to exist on the dates of November 5th and November 10th.
And with respect, Mr. Debberman, I disagree.
I would like to appeal.
You haven't even gotten that far. I may dismiss this case. You don't know what I'm going to do. If I dismiss it, do you want to appeal that?
No, Your Honor.
I wish to reserve all my rights.
There are repeated moments during this case that I have truly enjoyed nothing more your company and wit. Although I have to admit, every minute that I'm here takes these individuals away from what they have to do as well as I have. I'm sorry?
Oh, I'm losing work today also.
And then I'll make this decision as quick as I can. Anything else?
No, sir.
Mr. Devlin, anything else?
With all due respect, Judge, there's a motion outstanding.
Have a seat, please.
You can't be heard, sir?
I have a motion pending.
Sir, have a seat, please.
Has been even answered.
Yes, sir, have a seat.
Two things. When a court officer tells you to sit, you must sit or you will be removed. Now, I'm asking for whether or not you have anything else to say regarding the motion to the court.
No, Your Honor.
Now, sir, you indicated that you have a motion before the court.
Yes, Judge.
Your name for the record.
Posar, P-O-S-R.
Okay.
That motion was for a written order denying, as the court recalls, there was a motion for a camera in the court.
I recall.
The court denied that, told me to get minutes from the court reporter who never contacted me and didn't give me his card. So I brought a motion in today.
When did you serve?
Served it at 10:43 to the
10:43 this morning?
yes,
Court.
10:43.
You expect to serve a motion on the court at 10:43 in the morning and have it answered today?
I realize that under the circumstances, it would be very much appreciated if I could get that order since I've been waiting for like 2 months.
I understand to be appreciated. I'll do what I can to help. At the same point, to file a motion, you have to give adequate time. You have to, if you're requesting specifically again that something occurred, that something that would occur in court be recorded. What is your motion?
Motion for a written order denying the motion for camera in the court.
Well, I would grant that motion, but you must make arrangements with the court reporter because they do not do these transcripts for free.
He wouldn't give me his card, and he didn't call me when I gave my information. So now I'm only left with, if the court just says, no, I will not let you bring a camera in court and date it right on the back of this paper.
The decision was made from the bench.
Yes.
The transcript reflects that. The circumstances. Who is the court reporter? Del Tapper. Would you please request that Mr. Tapper transcribe that decision, and it will be provided to you. If you could leave with my secretary contact information.
I believe she has it. It's on its.
I've had it.
But I will.
It's been a long day, sir. We started at 9:30.
I'll speak to your secretary.
Thank you. And obviously, I have no problem receiving. Anyone else have any motions before the court?
Can I say something, sir? I would love to. It's honorable. I just want to say that they are medicine people.
If you're arguing on behalf of Mr. Barton and Mr. Debberman, no.
Okay.
Okay. Anything else?
Sure.
I'm asking you, does anyone else have a motion? Oh. Mr. Barton and Mr. Debberman, we have before me a motion to withdraw your plea. I believe that is the final motion that I have before me that I'm answering. And those motions have been made both in writing and also by oral arguments. The vast, overwhelming majority of the arguments that were raised by both Mr. Barton and Mr. Debberman in their motion papers have been either already decided by this court, waived by the pleas of guilty as an operation of law, or completely unsupported by the record of these proceedings. Specifically as to the allegations that their pleas were not voluntary, the defendants raised three specific arguments. First, that the arguments, their pleas, were coerced as a result of an assistant district attorney, I believe, by the name of Paula, representing that J. Debberman could be sentenced to a maximum of 5 1/2 years in state prison if convicted. The defendants maintain that as a first offender, he could receive only a sentence of probation. The defendant's statements are completely incorrect under the law, and the district attorney, if they cited the maximum sentence of 5 1/2 years in state prison, correctly represented the permissible maximum sentence this court imposed upon a conviction. The second argument is that since both were required to plead guilty or go to trial, the prosecution coerced the defendants into pleading guilty based upon their desire to protect each other. However, the courts of this state have repeatedly held that linked or connected pleas are valid and not inherently coerced. Finally, the defendants allege that they were rendered temporarily incapable of understanding the nature of the plea proceedings as a result of stress, lack of sleep, fear, despair, and, quote, phobia of injustice, unquote. These allegations are belied by the record of each plea, which unequivocally establishes that each defendant was fully aware of the nature of the proceedings and the consequences of their pleas of guilt. It is also directly contradicted by this court's own observations of the defendant's demeanor. That is, that they were alert, they were coherent, they were responsive, and in the court's opinion, understood the nature of the proceedings, the nature of their rights, and made knowing, intelligent, and voluntary waivers thereof. Accordingly, the court finds that the defendant's pleas were an informed choice, freely made among valid alternatives, and their motion where the pleas are in all respects denied. Gentlemen, that now takes us to sentencing. Mr. Barton, initially. Any legal cause why sentence cannot be imposed?
I would like to read this into the record, Your Honor, because I intend to appeal.
Mr. Barton, have you received a copy of the pre-sentence investigation?
No.
You have a legal right to have it. Would you be kind enough to provide that to Mr. Barton and also a copy to the court? Same thing for Mr. Debberman. Have you received a copy of the pre-sentence investigation? You have a right to have that, sir? Would you like some time to read that, sir?
Yes, Your Honor, I would.
Our court will take a 15-minute recess to permit both Mr. Barton and Mr. Debberman to review the pre-sentence investigation. Have you received a copy?
Yes, I have, Your Honor.
Court's recess to chambers.
From the start of these proceedings, we asked Judge Williams to recuse himself as to the fact that he helped form and fund the urgent strike team, which would be testifying against us in his court. We did not believe he could be impartial. Throughout all these proceedings, he has proven that he is not impartial. From the beginning, he took away assistance of counsel 2 previous judges had allowed. He told us he would hold us to the strict standards of a lawyer, knowing we were not lawyers, nor had legal educations. We were defending ourselves as sovereign human beings with all rights reserved. He refused to rule on many of our motions by picking and choosing only small bits to comment or rule on, and completely ignored many of our other arguments. He allowed the prosecutor to not answer many of our motions, who also refused to answer our bill of particulars, or provide many of the demands in our motions for discovery, such as the names of the urgent task force, so we could subpoena them besides other things that were never addressed by the prosecutor. Judge Williams held us to the strict standards of a lawyer and allowed the prosecutor advantages which denied us due process and equal protection, and put us at a disadvantage throughout all these proceedings. We believe Judge Williams has joined with the prosecutor in a conspiracy to protect his child urgent. From the very beginning, some of our first arguments were that the urgent strike team trespassed up a well-marked with no trespassing signs, half-mile driveway on 2 occasions, doing an investigation to obtain evidence which was the fruit of a poison tree, and voided any warrant. At the MAP hearing, we proved, with the urgent police officers' own testimony, that they indeed had searched our property by looking in windows and sniffing at our doors to gain evidence which never corroborated the anonymous informant's information. They should never have been granted a warrant due to lack of corroboration and the fruit of a poison tree. At that point, the prosecutor should have protected our rights to due process and equal protection and moved the court to dismiss in the interests of justice. Since the prosecutor did not move to dismiss, but continued to prosecute or coerce us into a plea bargain, The prosecutor was violating the law strictly to have a conviction. Judge Williams allowed this violation of the prosecutor's oath to protect and defend the Constitution and allowed the prosecutor to proceed. Judge Williams now violated his oath to protect and defend the Constitution by denying us due process and equal protection, and not dismissing the case himself in the interests of justice. Throughout these proceedings, the prosecutor and Judge Williams have acted in a lawless manner which voids any authority they had. Believing that there was no chance of a fair trial in Donald Williams' court, and believing the prosecutor when he said that Judge Williams probably would not throw out the case on the fruit of a poison tree, and that it probably would go to trial, we believed that the prosecutor and Judge Williams were working together. So we agreed to take the deal. In court, when Judge Williams asked us all the questions about the deal, we parroted the coerced answers to make the deal happen and not what we truly believed, as the real purpose of forcing this plea on us was to force us to give up our rights to appeal, a case we surely would have won. We hadn't yet realized until after the plea exactly what was going on. When we realized they had tricked us and in truth had been tricked into giving up our rights to appeal, which was the only place we could get justice, we went back the very next day as sovereign human beings, asserting a sovereign right to self-protection from deceptive practices on the part of the prosecutor and the judge. We withdrew our plea within 24 hours to preserve our rights, and true to any conspiracy, Judge Williams and the prosecutor attempted to coerce us by forcing a coerced plea down our throats. The prosecutor has committed fraud and violated his oath of office to protect and defend the Constitution and our rights to due process and equal protection, to protect urgents acting under color of law. Judge Williams allowed the prosecutor every advantage, even illegal, believing that we took the plea which as sovereign human beings we renounced the very next day. Judge Williams conspired further to violate our rights by saying it was within his discretion to take back the plea or force the plea on us. Judge Williams, knowing that Urgent trespassed without a warrant on 2 occasions, violating our rights, chose to force the plea on us rather than admit Urgent's wrongdoing. The prosecutor and Judge Williams have violated us in a conspiracy to cover up the crimes of Urgent by coercing us, tricking us, and using illegal maneuvers as if they were legal. From the time that the police trespassed on our property without a warrant, all jurisdiction was lost. Everything after that was a violation of our rights. The prosecutor lost jurisdiction when he violated our rights to due process and equal protection. Judge Williams lost jurisdiction when he allowed the prosecutor to violate our rights to due process and equal protection. Judge Williams further lost all jurisdiction when he conspired with the prosecutor to protect Urgent and force a guilty plea on us. Judge Williams' discretion throughout all these proceedings has been to put us at a disadvantage. Judge Williams has lost all jurisdiction, and to continue any further is malicious criminal intent to violate our right to due process and equal protection. And Judge Williams is not immune, as he has acted without legal authority. Judge Williams has failed to give honest service, violating his oath of office, conspired to violate our rights to due process and equal protection, and lacks any and all jurisdiction over us. Even the plea bargain that was offered has not been lived up to. The prosecutor told us if we took the deal there would be no jail, no probation, and no fine. In court, Judge Williams talked about a fine, but instead of a fine chose to keep illegally seized money that even the prosecutor admitted was not the proceedings of any drug transaction, but that the money belonged to the Freedom First political party. We believe that the Urgent Task Force, knowing of our involvement in the Freedom First political party and with New York Camp, New York Citizens Against Marijuana Prohibition, targeted us and selectively, illegally spied on us and arrested us to stop our political activities to repeal marijuana prohibition. The confiscation of Freedom First monies was to shut down our political movement and deny us our right to petition our government for redress of grievances. We believe Urgent singled us out for our political views and to put our political party out of action and render it inoperable. Once again, we state Judge Williams has lost all jurisdiction, and to continue any farther is malicious criminal intent to violate our right to due process and equal protection, and Judge Williams is not immune, as he has acted without legal authority. Judge Williams has failed to give honest service, violated his oath of office, conspired to violate our rights to due process and equal protection, and lacks any and all jurisdiction over us. And this is Joseph Barton, adopted by J. Debberman. I'll be signing it today, which is October 13th. Sovereign human beings speaking in their own right, Sui Juris, without prejudice, all rights reserved, under threat of slavery, UCC I-1-308, UCC 1-108.
Hey, hey, Paula, I want to marry you. Hey, hey, Paula, no one else could ever do. I've waited so long for school to be through. Paula, I can't wait no more for you. My love, my love.
Hey, Paul, I've been waiting for you. Hey, 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 Paul, I want to marry you too. If you love me true, if you love me still, our love will always be real. My love, my love.
True love means planning a life for two, being together the whole day through. True love means waiting and hoping that soon wishes we've made will come true. My love, my love. Hey, hey, Paula, I've been waiting for you.
Hey, hey, Paul, I want to marry you too.
True love means planning a life for two, being together the whole day through. True love means waiting and hoping that soon wishes we've made will come true. My love, my love.
A reefer smoker. Let's go, Jack, I'm red hot.
Unaware of the implications of the full-spectrum raid, we went about our daily business, which for me included a new job doing pizza delivery, and at night, staying up making small batches of the cure, 1 gram at a time. My girlfriend by my side, a rescued dog joining our team, making the cure for cancer, no longer wondering if it worked. It did, and my uncle was granted new life. Things were pretty good, except we had used all our weed to make my uncle's cure. So my best friend and business partner for the film company and I headed into a local dispensary to actually buy weed. As we got through security with ease, and I grabbed a cup of free goldfish crackers, the owner of the shop walked by and asked how I'd been doing. I casually mentioned that we had blown the skin cancer off my uncle's face, internally, rather than externally. His eyes went wide. He said we should hold a press conference right there at the dispensary, announce our cure and success story, and announce a test of 10 patients. That would be something. The dispensary owner hustled us into his private back room, where a very powerful and expensive lawyer and large businessman sat. As the dispensary owner introduced us and pitched the idea of our press conference and test of 10 to the millionaire men, they looked over our brochure. Both men began to scowl. When they spoke, we listened. We have recreated the conversation as follows. So, what do you think about the idea of us holding a press conference to announce a cancer cure story?
No, not at all.
Why not?
Let me tell you exactly why not. For starters, just calling the Phoenix Tears medication the cure is an FDA violation, and they will swoop in on you just like the DEA for not going through the 100,000-page application and 5-year process to release a new drug. And speaking of the DEA, you are also using a federally banned substance to make this product, which is a double whammy. A DEA illegal, federally classified Schedule I substance to make an illegal FDA product.
So?
You are facing a minimum of 5 to 40-year federal prison sentence if you release your product publicly. And if you even tell anyone you have cured cancer using it or give out your brochure, you face the same fate. And on top of that, you call your product The Cure, which is a trademark violation for the rock band The Cure, and they could choose to sue you as well.
Whoa, seriously? 5 to 40 years for trying to bring a product that cured my uncle's cancer to market and labeling it inappropriately? All still legal by Colorado state law, but illegal under federal law? And we might piss off Robert Smith of the band The Cure?
Exactly. And what's worse, if you go to federal court, you are for this. They will not let you use your uncle's cancer cure as a legitimate reason for violating the laws. You need to destroy all your paperwork immediately and get it back from everyone who has it.
Oh, shit.
What?
Nothing.
No, say what you were going to say.
Well, it's just we submitted a brochure to Full Spectrum Labs right before the raid, and the DEA already has it.
What? Say that again? You were mumbling a little bit.
I said the DEA already has our brochure and paperwork and a vial of the Simpsons oil, which we had labeled as The Cure, which they took in the raid at the Full Spectrum Labs.
Ho 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 ho. You're
What?
You're so
Why?
The DEA took your paperwork. They already have a case against you. Get rid of all your guns and anything you may have that's illegal. They are going to make arrests any time now, probably the 1st of the month.
Arrests in a week?
Yeah, we'll call you if they're going to bust you.
What about a press conference and the cancer cure?
You don't get it, do you? They already have you on an automatic conviction in federal court for 5 to 40 years. All they have to do is show the judge your brochure calling your product The Cure, and you go away, never to be heard from again. You gave them all they needed for an easy conviction, dead to rights. I would advise you not only not to have a press conference, but to stop talking about this publicly immediately. You know they already have a patent on this, don't you?
What?
The federal government has a patent on the medication you are making. You violate federal patent law as well when you make the oil and use it.
No way. That's conspiracy stuff. We leave the dispensary shell-shocked, having just been told we were about to be arrested for curing my uncle's cancer. When we got home, we immediately looked up all the legalities we had been told and Googled the patent information. It's all true. U.S. Department of Health and Human Services patent number 6630507 from October of 2003 states all the scientific evidence and studies on how cannabis ingredients inside the body are found to have particular application as neuroprotectants for use in the treatment of neurodegenerative diseases such as Alzheimer's disease, Parkinson's, HIV, dementia. The United States government already owns the patent on the cure for cancer, and it states with scientific backing exactly how the medicine works on the cannabinoid receptors throughout the body. How could this be, though? How could the medication that cured my uncle's cancer be already patented by the U.S. government, and yet still illegal and worse, unused? This was starting to not make any sense. We violated FDA, DEA, U.S. patent and copyright laws while doing this, yet we are 100% legal according to Colorado state constitutional law. And a lawyer telling us to lose our guns, we are going to be arrested? What the hell happened to the country I love? Please stay tuned for more information.
So the guy who got 15 years, Bozar,
Yeah.
is there a way that we can get the Debberman Barton thing to work together?
That's a really big job, because what you're talking about, like in Texas, I don't know about Mississippi, I mean the recent stuff in Texas about certain law enforcement just actually planting drugs, you know, really making up stories. I mean,
is urgent terrorizing black people more than white people?
I'm not up here, so I don't know what's
Abigail, do
happening
you know
up
that?
here. But the question is, that is the question. Who are they doing it to? You gotta. Who are getting these no-knock warrants or these courtesy calls? I mean, who's getting them? I don't even know.
Well, white people as well as black people are getting the no courtesy calls. Yeah, anybody that's living in these projects
years.
or
that guy got
places
15
where
years. So I mean, what did you guys think?
Part of what hurt that guy was his past record. But his past record, they said his violent stuff was all before 96, which is 15 years.
Yeah.
According to the law in this court, stuff used before 10 years. They can't go back past 10 years, but they used what he did 10 years back, and they just used it against him, which they're not supposed to bring that into court.
Now, what about the central core?
But he probably don't know that.
I know. Well, that's why I have his name right here.
You guys, the central thing of what you were fighting for was religious use. Could your understanding
religious and medical, both.
Religious and medical. Could your understanding of that have been provided a more profound platform for this guy who, you know, he said you're giving poisons to the community, and
I don't know what drugs he was dealing with, so that never came up. So I don't know. I can't.
They did not have in the case. He did. The judge mentioned marijuana.
They had him on sales. They did not have us on sales. And part of the reason they gave us.
But even sales has to be dealt with. If you're talking, Abigail, just a second. Even in the case of sales, if you're talking about real medicine, where's the crime? You know. And I'm just thinking,
I don't think that guy put the medical argument before the court.
I know he didn't. I think he's ignorant. See, now we're talking about ignorance.
I don't know
that's
what drugs he was
Yes, I went up to Google and learned about Don Williams, your Honorable Don Williams. He's not so honorable. When they time to swear him in, they would usually use a Bible. They didn't have a Bible. He said, "Get me a dictionary." Now, the press got wind of this and made a big deal that he's above the law. He used a dictionary. He says, "Oh, the next time we'll use a Bible." But he is known to have started the task forces. He put the most number of people in jail for just this kind of a thing. And when you have to study a person's behavior, which is probably traditional cognitive behavior, he's going to continue doing it just because he's done it before and he thinks he can always do it. He's not a guy who can make change. Therefore, he shouldn't be a judge.
Can you identify yourself?
I'm Shelley Lipton. I'm the director of the Woodstock Museum in Woodstock, New York.
Now, as the director of the Woodstock Museum, do you think Urgent is protecting or terrorizing the population?
Who?
Urgent.
The Urgent Task Force.
Oh, just the term task force is already using a term force. If you already keep that in your vernacular, you're coming up against negative energy, a force. I don't think even that kind of a word can have anything to do with rehabilitation or taking people in that may be doing wrong but need to be doing right. So I don't even like the word task force. But clearly, the man is out to get you. And his smirking and smiling in the courtroom, I couldn't even help myself. I said, "That's not funny."
No. Now, what about, does anybody want to make a statement about white folks getting off better than black folks?
Yeah, I will. I will. I've been through this court, and I've sat here through this court, and I've watched black person after black person who are not aware of their rights, not only make deals with the prosecutors that say, okay, I'm going to take this plea bargain, and then they think they're going to get a certain deal, and then when it goes before the judge, this judge, Don Williams, has said on numerous occasions, I've watched it with almost every black person that's come before this court, he say, you made that deal with the prosecutor, you didn't make that deal with me. And after they had pled guilty, he sentenced them to a more severe sentence than the agreement was made. And I think, you know, this court is a racist court. Even though I'm white and I don't feel that I got justice, I feel that the black people that go before this court get less than what we've got.
Right, as evidenced by that.
Hey, hey, Paula, I want to marry you. Hey, hey, Paula, no one else could ever do. I've waited so long for school to be through. Paula, I can't wait no more for you. My love, my love.
Hey, Paul, I've been waiting for you. Hey, 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 Paul, I want to marry you too. If you love me true, if you love me straight, our love will always be real. My love.
True love means planning a life for two, being together the whole day through. True love means waiting and hoping that soon wishes we've made will come true. My love, my love. Hey, hey, Paula, I've been waiting for you.
Hey, hey, Paul, I want to marry you too.
True love means planning a life for two, being together the whole day through. True love means waiting and hoping that soon wishes we've made will come true. My love, my love.
Pretty Polly Blossom, what's wrong with you? Your body's kind of weak and you think there's nothing we can do. Good golly, Polly, shame on you. 'Cause Molly made a stew that'll make a new